potential defense is when the landlord was required to serve a termination notice. The defendant never received the notice. The notice does not afford the tenant the statutorily required number of days, 5 days, 10 days, 14 days, 30 days, whatever it was. Or the landlord filed the eviction action prematurely, in other words, before the time period set forth in the termination notice expired. If the tenant got a 5-day or 14-day notice demanding payment of the rent due, you can argue that she actually didn't know the rent. She was current in her rent payments when the notice was served. Or that she paid the rent due or tendered the rent due before the termination notice expired. If the tenant tenders the amount due and the landlord rejects it, that is an absolute defense to the eviction action. Of course, proving that you tendered the rent and the landlord rejected it might be a little difficult, and that's why, as either Paul or David mentioned, you should always advise your client, if you're lucky enough to have them come to you before the termination notice is actually expired, that they should have a witness with them when they tender the rent, and that they should write down where they tendered it, to whom they tendered it, when they tendered it. Another very common defense, commonly known as the Jack Spring defense, because there's a case, an Illinois Supreme Court case called Jack Spring on this issue. The plaintiff's failure to maintain the premises reduced the value of the premises by an amount that exceeds the rent owed. It's an extremely common defense. Or the rent demanded represents an amount that the defendant had to pay for utility services that the plaintiff was responsible for providing. This is the kind of defense you'd raise pursuant to the Rental Property Utility Services Act. Sometimes your client will be in a situation, this happens a lot in private housing, in which the landlord is responsible for providing the utility services, but they haven't paid the utility bill, so then the tenant gets a shut-off notice from the utility company. The Rental Property Utility Services Act allows the tenant to take their rent money and give it to the utility company and keep the services on. And if that's why, or if that's what the tenant is doing with her rent, she cannot be evicted for non-payment of rent. Potential defenses when the tenant received a 10-day notice alleging that she violated the lease agreement. She never committed the alleged violation, or that her conduct does not constitute a material lease violation. You can only be evicted in Illinois for committing material lease violations. That the tenant cured, if the RLTO applies. Or a very common defense, that the plaintiff recognized the existence of the defendant's tenancy after learning about the alleged lease violation and thereby waived its right to pursue the eviction action. Now, there's going to be a question as to what acts constitute recognizing the tenancy. The most common one is accepting rent, right? So if the landlord accepts the tenant's rent after learning that the tenant had committed a lease violation, he's waived his right to pursue enforceable action. Right? Potential defenses when there was a 7 or 30-day notice served. Most common one, the defendant has a written lease agreement which is still in effect and cannot be terminated without good cause. The notice was served in an untimely manner. This always happens in 30-day notice cases. Landlords always miscalculate the day on which they're supposed to serve the notice. The plaintiff is retaliating against the tenant and either violating the RLTO's prohibition against retaliatory conduct, or there is a state statute, the Retaliatory Eviction Act. The Retaliatory Eviction Act says that you cannot evict the tenant because she complained to a government agency about code violations. That's the only protected activity in the statute. However, there is a case called Wood v. Wood that I was not involved in that says, well, we want to expand the definition of protected activity. And we're not going to say exactly how we're expanding that definition, but if it might really violate public policy to allow landlords to retaliate against tenants for engaging in certain actions. So we're going to say that sometimes you can expand the definition of protected activity that's set forth in the Retaliatory Eviction Act.